In a case called Geo Group v. Menocal, the Supreme Court focused on that timing question for federal contractors who say they were just following lawful government authorization. Justice Elena Kagan wrote for the court that the rule from an older case, Yearsley, gives contractors a defense they can use to fight liability on the merits, but it is not a free pass that shields them from having to stay in the case at all. And that matters, because the court said if a trial judge rejects that Yearsley protection before trial, the contractor usually cannot take an immediate appeal right then. Instead, the court said that kind of denial is not one of those rare appeal now orders under federal law and the collateral order doctrine. It can be reviewed after the case reaches a final judgment. The Chief Justice and Justices Sotomayor, Gorsuch, Kavanaugh, Barrett, and Jackson joined Justice Kagan's opinion. Justice Thomas agreed with parts of it and the final result, and Justice Alito agreed with the result. Keep listening, because this ruling draws a sharp line between a defense you can raise at the end and a special protection that lets you try to get out of court at the very start. Nine Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. The Supreme Court recently tackled a question that sounds simple, but has major legal consequences. When a federal contractor like Geo Group claims it should be dismissed from a lawsuit because it was just following government orders, and the trial judge says no, can the contractor appeal right away? Or does it have to wait until the entire trial is finished? The court's answer was clear. Wait until trial. Justice Kagan, writing for 6 justices, explained that the legal protection contractors claim, known as the Yearsley Doctrine, is a defense against being found liable. It is not immunity from being sued in the first place. This distinction matters a lot when deciding whether someone can appeal immediately. Here's what happened. Geo operated a detention facility for Immigration and Customs Enforcement in Colorado. People detained there filed a lawsuit. They claimed Geo's work policies violated federal laws against forced labor. These policies included unpaid cleaning duties and a so-called voluntary work program that paid just 1 cent per day. Geo argued it should be protected because ICE had authorized these policies. The trial court disagreed, finding that Geo's contract didn't actually require these specific policies. Geo tried to appeal immediately. The 10th Circuit said it didn't have jurisdiction to hear the appeal yet. The Supreme Court agreed with that decision. The oral arguments showed the real tension in this case. Dominic Dre, representing Geo, made an argument about fairness that got several justices thinking. He asked, why should Geo, doing exactly the same work as ICE employees in the same facility, be unable to appeal immediately when those ICE employees could appeal right away if they claimed qualified immunity? This practical unfairness particularly resonated with Justices Alito and Kavanaugh. Dre pointed to a long tradition in common law. He said that agents acting under valid government authority have always enjoyed immunity from being sued. He made a distinction between whether Congress has the constitutional power to authorize something and whether a specific authorization was lawful under existing statutes. Under his reading, a contractor could have immunity even if it violated a statute, as long as Congress had the constitutional power to authorize the underlying activity. This proved controversial. Jennifer Bennett represented Menocal and the other detainees. The government also supported her position. She argued that Yearsley simply lets contractors show they acted lawfully. That's a defense on the merits, not immunity. She walked through historical cases showing that agents have never had derivative sovereign immunity. The fact that the government opposed Geo, even though it acknowledged Yearsley's importance, carried substantial weight. As Justice Kavanaugh noted, This seemed like a big hurdle for GEO to overcome. If the government itself didn't believe immediate appeals were necessary, perhaps they weren't. Bennett also highlighted a practical problem with GEO's theory. Figuring out what the government actually authorized and directed requires digging deep into the facts. You have to compare what the contractor actually did against what the contract said, what the regulations required, what emails instructed, and what verbal directions were given. Justice Sotomayor suggested this factual complexity provided a simple answer for denying immediate appeals without having to resolve deeper immunity questions. The most revealing moment in oral argument came when Justice Jackson posed a logical puzzle. In the original Yearsley case, the government had waived sovereign immunity because takings require compensation. She asked, wouldn't we have a very odd scenario in which the contractor would somehow be given immunity, but the government itself wouldn't? This exposed a fundamental problem with the theory that contractors get immunity derived from the government. Justice Kagan's majority opinion builds a clean framework for distinguishing between defenses on the merits and immunities. The Supreme Court's decision draws an important distinction between two different ways defendants can avoid liability. A defense on the merits argues that the defendant acted lawfully and therefore shouldn't be held responsible. An immunity, by contrast, is a shield that protects someone even if they did break the law. This distinction matters because it determines whether a defendant can appeal a court's decision right away or must wait until the case is fully resolved. The timing of appeals depends on the type of protection at stake. With immunity, waiting for a full trial defeats the whole purpose. Immunity is meant to avoid trial altogether. So when a court denies immunity, that decision can be appealed immediately. With a defense on the merits, however, there's no rush. If a defendant loses at trial but had a valid defense, an appeals court can simply overturn the verdict. The defendant's rights are fully protected even after the trial concludes, so waiting for final judgment doesn't cause any harm. The court concluded that the legal doctrine in question operates as a defense on the merits, not as immunity. The key reasons: the doctrine only protects conduct that was actually authorized and lawful. Historical legal precedent doesn't support extending government immunity to private contractors, and an earlier court decision explicitly described similar protections as a defense rather than immunity. Because it's a defense on the merits, not immunity, the normal rules apply. Defendants must wait for the case to conclude before appealing. Justice Thomas agreed with the outcome but objected to the court's broader reasoning about when appeals can happen before a case is fully resolved. Thomas has long worried that judges are making too many exceptions to the rule requiring cases to finish before appeal. He believes Congress and not individual judges should decide when those exceptions apply. Congress has already established specific exceptions through law and authorized the court to create more through formal rulemaking procedures. Allowing judges to create exceptions case by case through their written opinions, Thomas argues, bypasses the proper process. Since previous court decisions never allowed immediate appeals in situations like this one, Thomas would have kept the final judgment rule in place without exception. Justice Alito also disagreed with the majority's reasoning, but agreed with the final decision. Rather than focusing on whether a defense requires proving lawful conduct, Alito suggested courts should ask whether delaying an appeal would harm an important public interest. For some protections, like qualified immunity for government officials, immediate appeals do serve the public interest. They ensure officials aren't overly cautious. But Alito saw no such compelling public interest for this particular doctrine. He noted that contractors already have qualified immunity, which offers even stronger protection. Since that broader protection already exists and doesn't require immediate appeals, there's no urgent reason to make exceptions for this narrower doctrine. This case answers a narrow but important question. If you're a private company doing work for the federal government and you get sued, you can't immediately appeal to a higher court just because you say the government told you to do it. You have to go through the trial first, make your case there, and appeal afterward like everyone else. The practical impact falls squarely on companies that run federal facilities, build federal projects, or carry out federal programs. These contractors may still argue they were following lawful government direction. They may win on that argument, but they don't get to treat that argument as a get-out-of-court-free card that lets them skip the trial process entirely. That privilege is reserved for true immunities, like the qualified immunity government employees themselves enjoy. The deeper issue is about accountability. When the government outsources work to private companies, those companies step into a gray zone between public authority and private responsibility. The court is saying that operating in that zone doesn't entitle you to the same legal shortcuts the government gets. If a contractor's conduct was lawful, the trial will bear that out. But the people bringing the lawsuit are entitled to their day in court first. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.